For your kind attention, ladies and gentlemen, we are just about to begin our today's program, and we request everyone to please get settled. For those of you who are outside, and if you can hear me, we request you to please join us inside the hall now, and feel free to bring in your cups of tea and coffee. Join us for the program as we are now starting today's conference. Requesting everyone who is outside, and if they can hear me, to please join us for the inaugural session now. And a quick and humble reminder to everyone to kindly place their phones in a silent mode. Thank you. Today's program, Shri Ashok Kumar Gupta, IAS Chairperson, Competition Commission of India, Government of India. Also joining us this morning, Dr. Harshvardhan Singh, former member CLRC and former Deputy Director General WTO, former Economic Advisor and Secretary TRI. Requesting our Chief Guest, our Guest of Honor, Mr. Manas Kumar Chaudhary, Mr. Basudev Mukherjee and Mr. Karan Singh Chandiok to join us for the lamp lighting ceremony. Lighting the auspicious lamp to seek the blessings of the Almighty and thank Him for a new day of learning. With that, our today's program has formally been inaugurated now. Ladies and gentlemen, namaskar and good morning, and a very warm welcome to the 7th Annual International Conference on Competition Law. Enforcement in India, the past, present and the future is the theme for our today's program. The program is brought to you by ASSOCHAM India in association with the Competition Commission of India. And now joining us on the dais, our chief guest, Shri Ashok Kumar Gupta, Chairperson, Competition Commission of India, Government of India. Let's all welcome him with a huge round of applause, ladies and gentlemen. And I'll also request you to please join me in welcoming Dr. Harshvardhan Singh, former member CLRC, former Deputy Director General WTO, and former Economic Advisor and Secretary TRI. Also joining us this morning for the inaugural session, now we have Mr. Basudev Mukherjee, Assistant Secretary General ASSOCHAM, Mr. Manas Kumar Chaudhary, Chairman ASSOCHAM National Council on Competition Law and partner Khaitan and Company, and Mr. Karan Singh Chandiok, co-chair of the ASSOCHAM National Council on Competition Law and practice head Competition Law and Dispute Resolution, Chandiok and Mahajan Advocates and Solicitors. Now to begin with our today's program, we'd like to first of all extend our heartiest welcome to our chief guest and our guest of honor. I'm going to first of all request Mr. Basudev Mukherjee and Mr. Manas Kumar Chaudhary to kindly welcome Shri Ashok Kumar Gupta on behalf of all of us here at ASSOCHAM with a plant sapling, which is symbolic of growth and prosperity. ASSOCHAM going green. This is a little welcome from our end to Shri Ashok Kumar Gupta, wishing him growth and prosperity. And I request Mr. Basudev Mukherjee and Mr. Karan Singh Chandiok to kindly present a plant sapling to Dr. Harshvardhan Singh and welcome him. Without any ado, let me first invite Mr. Basudev Mukherjee, Assistant Secretary General ASSOCHAM, to give the welcome address.
Mr. Ashok Kumar Gupta, IAS Chairperson, Competition Commission of India, Government of India. Dr. Harshvardhan Singh, former member, Company Law Review Committee and former Deputy Director General, WTO, and former Economic Advisor and Secretary TRI. Ms. Jyoti Jingar Bhanot, Advisor and Secretary in Competition Commissioner of India, Senior Advisors, officials from CCI, Mr. Manas Kumar Chaudhary, Chairman, ASSOCHAM National Council on Competition Law, and partner Khaitan and Company. Mr. Karan Singh Chandiok, Co-Chairman, ASSOCHAM National Council on Competition Law, and Practice Head, Competition Law and Dispute Resolution, Chandiok and Mahajan, Advocates and Solicitors. Good morning and a very warm welcome to all of you to this very special conference on competition law. At the outset, let me apologize for the absence of Mr. Deepak Sood, who has been called away on official work and he's traveling today. Competition law plays a pivotal role, especially towards protection of the interests of the consumers, and ensures equal opportunities to all the players by eliminating anti-competitive practices such as monopoly, self-preferencing, dominance, and cartelization. In the post-pandemic scenario, the market is evolving faster and new markets are coming up, which is unlike in the past. While a significant portion of the existing market and its functioning is under transformation due to digitalization, the new markets such as online aggregators, OTT platforms, e-commerce are evolving with lightning speed. This throws a dynamic challenge on the regulators, practitioners, and those regulated ones. Being a chamber of commerce and industry, ASSOCHAM keeps gathering such multifaceted challenges, which is from the industry point of view, and underscores the need of addressing such challenges through policy dialogues and advocacy initiatives from time to time. From establishing a business and running it, and then from expanding the same to winding up by way of acquisition, the competition law plays a very crucial role. It is commendable that the way the Competition Commission of India, especially under the leadership of Shri Ashok Kumar Gupta, being chairman of CCI, has regulated and amended the ACT and maintained a high level of benchmarks, which is at par with international best practices. And sir, we hope your contribution for advocacy of competition Competition Act will be remembered in the years to come. We are truly honored to have you this morning with us. As the dynamics of the market are changing rapidly due to technological advancements, artificial intelligence, and the increasing importance of factors other than price amendments became necessary to sustain and promote market competition. The Competition Amendment Bill 2022 is one such amendment which aligns to meet the evolving market conditions. This annual conference is an endeavor to bring all stakeholders together, discuss and deliberate and highlight such challenges and carve a way forward towards better governance and thereby enhance ease of doing business for industry. I once again welcome all the eminent guests and speakers on the dais and off the dais, as well as participants to the conference for taking your time and making it to this conference, making this conference a great success. Thank you.
Thank you, Mr. Mukherjee. I now invite for the opening remarks and knowledge partner address, Mr. Manas Kumar Chaudhary, Chairman of ASSOCHAM National Council on Competition Law, and partner Khaitan and Company. Mr. Chaudhary, ladies and gentlemen, is an antitrust litigator, advises Indian and overseas clients on competition law and policy and related legal regulatory issues, including merger control. And prior to joining the profession as a full-time lawyer, he has also, in fact, served as a civil judge in the West Bengal State Judicial Services, Director Legal, MRTP Commission, and Additional Registrar Legal with the Competition Commission of India, and is in fact highly ranked by the global ranking agencies for years, a member of the Competition Law Review Committee of India and the IBA Antitrust Litigation Working Group. Let's welcome him with a round of applause.
My heartiest welcome to everyone. Good morning, sir, and good morning, Dr. Harshvardhan, my co-chair, Karan and Basudev. It's a pleasure to be back in person because we have been doing this online for now last 2 years, but then we have not been stopping from sharing our thoughts through the platform of ASSOCHAM Competition Law Committee. But it is good to be back in person, meeting people, and that's what the law and the practice is going to be in future. We already have the appellate tribunal in full in-person functioning, and we hope that the CCI too would be very soon in person in times to come. Because at the end of the day, online has really helped us, and for that, I congratulate Chairman for two reasons. I am practically trying to make my presentation in 3 phases. Since I am associated with the Competition Act right from day 2000, when this bill was presented in Parliament in August of 2000, thereafter there was the assent of the President on 13th January 2003, then the phase started of certain writ petitions without really substantive provisions being ever under challenge. Only the structure of the Competition Commission was under challenge. That actually helped the court not to really grant any stay to the substantive provisions of the law. In 2007, the amendment happened. So the first phase of this act is the initial teething problems between 2003 and 2007. After the amendment has taken place, then obviously the basic foundation stone for setting up of the commission, the regulations, the appointments, etc., all happened between September 2007 and May of 2009. And from 2009 May onwards, first the enforcement activities of the commission in terms of section 3 and 4 were notified, and thereafter on 1st June 2011, merger control was notified. So 3 phases. Obviously, Competition Act being so market-facing, dynamic economic legislation, without the consultation process of the industry and the stakeholders, it was not really possible to have this law implemented on the very first day. Even if we call the grandfather of the antitrust, the United States, which of course had its first competition law, Sherman Act in 1890, it took 86 years to come up with a merger control provision in 1976. So we can imagine, we have had our antitrust law on 20th May 2009, on 1st of June 2011, we had the merger control kicking. That clearly showed that we were really going right onto the direction as what the entire international jurisprudence wanted us to do. It's one of the best modern economic legislation. I always try to go back to one of the very interesting statements which I generally try to share with audience. Way back in 2007, in the annual report of the OECD, I still remember page number 109, OECD talked about Competition Act of India as it is a state-of-the-art legislation. It never said so for many legislations, but it did say about the Indian Competition Act. Answer is very simple. We have all the ingredients of a modern competition law, the antitrust, enforcement, the merger control, regulation. And in that space, the CCI had done a commendable job. Why I am saying? Because I am associated with the evolution of the law. The first phase of the implementation, that is between 2009 and 2011-12, we have had the first set of competition evolution started. Immediately we found a very interesting Supreme Court intervention, whether the prima facie order of 26(1) should be appealable. The court came to the right conclusion, and that actually led the right direction, and that is the first approval of the CCI's functioning as enunciated by Supreme Court, and that became law of the land. The second phase, which started off with Mr. Ashok Chawla taking over as the chairman CCI, we saw the public sector undertakings being investigated. To name a few, Coal India Limited, public sector insurance companies, and all these orders have been confirmed in the appellate tribunal. That clearly shows that the thinking and the processes laid down in the law was properly being implemented by the commission. Third phase saw, when Mr. Sikri took over, we have had the beginning of the leniency regime in India. That went off very well, and the last stage, most illustrious stage in my view, of Mr. Ashok Kumar Gupta. Why I am saying so? He started off, thank you. He started off in 2018, and we had a very remarkable decision on 25th October 2018. There was always a thinking that insofar as trade associations are concerned, there can be no provision relating to implementation of section 3 and 4. Mr. Ashok Gupta had come out with a very nuanced view that since the enterprises who are actually part of the trade association are engaged in economic activities, hence enterprises must come within the ambit of enterprise, hence they are amenable to section 3 and 4. Earlier, people were of the view that section 4 could not have been applied for trade association, and he made the real departure, which I don't think can be even questioned, because prior to that, already in the West Bengal Coordination Committee, Supreme Court held that view. That's the first remarkable, thank you for that, sir. Second came the very interesting departure of Green Channel in August of 2019. When August 2019 Green Channel was introduced, initially we were all not very sure, but definitely it, as on today, when I see retrospectively, the waiting period has minimized to 0. Any industry who would like to really file a merger control would like to see that the waiting period is minimum, and here the waiting period is 0. Yet, the Green Channel transactions have actually helped the industry in the sense that it is actually process-wise the same. Either you file Form 1, even possibly Form 2, but end of the day, if you are able to prove that there is no overlap in any of the markets, your approval is on the day you have filed the application. That's a great innovation, sir. And I think the whole world acknowledges that this is one of the finest innovation created by current chairperson. And the last phase of chairperson is the most dynamic. I'm talking about 23 March 2020, when the whole world had seen the close down of the entire industry, and we were thinking as to how the Competition Commission would function. The online things was to come, 19th April 2020. Sir, I remember we were talking as to how the advisory will have to be issued, and the advisory came from the CCI, which actually given rise to some kind of a predictability with regard to the healthcare sector, essential services sector, and online. Will they coordinate? How they coordinate? And when they coordinate? Will that fall foul of antitrust law? The advisory clearly spelled out, barring certain delta, it is not actually going to give any exemption to Competition Act, but only with regard to if you have a justification, why do you coordinate, then it becomes acceptable, because that was the global norm by that time. Then came 6th October 2020, we had the standard operating procedure for online hearing, and we are very happy, Karan, we all were the first to make the online hearing before the Honorable Commission, and the orders which were passed via the route of online were tremendous, wonderful, and we all, including the, including the industry, was extremely satisfied the way the online hearings have been continuing until date. For example, in merger control, I remember we were also having pre-filing consultations. All credit goes to Mr. Govil for helping us. Way late in nights, we were having those overseas clients, PFCs, all online, and the clients were extremely happy. I remember they wanted that their long stop date was coming to close on 11th of August, and you were equal to them. You gave them the approval through the commission on 6th of August, and it was all online. And it was a global merger of Form 2. We can imagine that even on an online or an offline, it's always a very difficult proposition, because we had to define markets at all places. So in conclusion, what I'm trying to say here is that the Commission, from phases of 2003 until today, has really gone in leaps and bounds. The industry, the stakeholders, all started sharing the same view that yes, here is an organization, here is an authority, which is always able to give us an opportunity to consult. Even in the amendment bill, I remember when we were there since 2018, when the government of India had decided to have the CLRC. It was all through consultation process that what we have got today, the amendment bill which has been placed in the parliament. The Competition Act of 2002, Mr. Pranab Mukherjee, the late president, he was the chairperson. We appeared before him. We had submitted quite a number of points. Then General Khanduri, then even the act which lapsed, Mr. Jaswant Sinha, and now the final amendment bill. This consultation process had actually made what we are today. I wish that we would like to really continue with helping the industry association and the commission. And briefly, what our knowledge paper today talks about is, only briefly, I would not be touching upon more because that would be shared as soon as it is released. It's talking about a bit about the amendment bill. We are also talking about the vertical block exemptions which had been introduced in European Union on 1st of June 2022, which would make the vertical markets more informative, more competitive, and perhaps sometime down the line, CCI would also have a persuasive value in adopting those new vertical block exemptions of EU. Single economic entity sometimes had been held to be not really throwing up of an anti-competitive issue, but there was a departure in the ship liners case, and we wait and watch how this jurisprudence evolve. Revised Form 2, of course, is wonderful change, but at the same time, we are trying to cover in this knowledge paper. The 5 years market-facing information may at times becomes little complicated. If we can really have some ease of having that, that would be quite good. Artificial intelligence, yes, that's an area which is talk of the town, talk of every jurisprudence, that yes, we would like to see how collusion in the algorithm can lead to an antitrust issue and when it is not. Because every business agreement is not anti-competitive. It is the delta which is mostly affecting the interest of the CCI, or for that matter, any competition agency. Every business agreement cannot be anti-competitive. So that is where, the catch is, how do we distinguish between a digital market and a traditional market? And lastly, we are talking a bit about penalty, though there is a lot of predictability, which of course, during the COVID period, most of the cases which were parties were involved from SME, MSME, CCI had given clarity as to why penalty cannot be imposed despite a cease and desist order can be given. But at the same time, in some cases, for example, in resale price maintenance or even the beer cases, the penalties were imposed because it was definitely not an issue of MSME. So with that, predictability is coming, but the amendment bill is trying to bring that within the ambit of the substantive law. We are covering all of that in our knowledge paper, and I think as soon as it is released, you will have an opportunity to read it in more details. Today's program is being followed by 3 technical sessions, and the technical sessions usually will have the normal abuse of dominance, vertical agreement, settlement commitment, amendment bill, and that's all which we are going to have today. With that, I end my short speech. I wish that this program makes everyone better off than what we until yesterday knew about this entire business of competition law. There should be some takeaways today. And I am aware that we would be having very interesting discussions. The moderators and the chairpersons of these technical sessions are experts in their own rights, and we'll have a very wonderful time. With that, thank you very much, and I welcome you all. Thank you.
Well, thank you very much, Mr. Chaudhary, for talking to us and sharing with us those insights. It's time for me to now invite our guest of honor, Dr. Harsh Vardhan Singh, to kindly give his address. Ladies and gentlemen, he comes with extensive international and national experience on trade and investment matters. In fact, in 2 separate stints, he's worked at the GATT WTO for a total of 20 years, 8 years as the Deputy Director General WTO, and was also, in fact, the economic advisor and then the Secretary Telecom Regulatory Authority of India in its initial 8 years. His high-level expert engagements in the past 10 years include member high-level advisory group on international trade established by the Government of India, member competition law review committee to revise the Competition Act established by the Government of India, included responsibility as the chairperson, working group on new age markets and big data. Let's all welcome him with a round of applause.
Good morning, everyone. A special welcome to the chief guest, Mr. Gupta, Chairman CCI, Mr. Manas Chaudhary, Basudev Mukherjee, Karan Singh Chandiok, honorable guests, and ladies and gentlemen. I want to begin by complimenting the CCI, especially because in the difficult period of COVID-19, it continued its work. It digitalized, it enabled work to continue without any significant interruptions. The investigations continued under COVID, and a number of initiatives were taken which also took the understanding and the basis of competition policy to deeper levels. In fact, I was reading a paper on the emerging issues in competition policy, and I saw there was an example of a decision of the CCI given in that paper, which illustrated the application of economic insights and theories for getting a conclusion on under the theory of harm. So my congratulations for the work which is going on, and the clarity with which I've seen in my discussions with you, Mr. Gupta. I think that much of what Mr. Manas Chaudhary said boils down to the fact that the CCI and you in particular, because I have interacted with you, I've seen a great clarity of perspective and a forward-looking perspective. So I congratulate you all. Now, one of the things examples which Mr. Manas Chaudhary gave was the green channel, as you called it, which reduces the time taken. Now, time is very important for two reasons. One, it is actually a cost. It imposes costs in multiple ways. And two, it gives greater certainty, because with clarity, if a decision is given in a timely manner, that is far more useful to build up the structure than something which is delayed. I recall as a student, my professor told me, and I was surprised by that concept, that in Austrian economics, time is treated as capital, investment, which means that the more time you take in a process, higher the capital output ratio, which is an inefficient way of looking at things. So I'll come back to timely decisions in another context, but it also struck me that when you look at what is the objective of competition policy, the basis of that is from economic perspectives on consumer welfare. At the same time, when you really expand the zone of operations, competition, though competition policy is jurisdictional specific, the fact of whether competition is arising or anti-competitive activity is taking place today is an accepted fact that it also is a transnational phenomena. There was a time when transfer pricing, etc., were seen as examples of this. Today, the concern about practices of certain countries which have an impact on business opportunities in other countries are very much front and center in public policy discussions. So, what is the economics of competition policy? In a very simple way, it is that the action should lead to increase in consumer welfare. I mean, that is the litmus test. However, consumer welfare is something which has to be seen in today's context and in the near future. So that's where predation becomes an issue. But the other aspect is that while it is based on this simple thesis, the economic decision-making is getting more complex within firms. And when that happens, then the nature of actions which will be pro-competitive or anti-competitive, it cannot be determined without adequate assessment, say, under the theory of harm. In this background, we also have to see what are the other actions or policies which result in greater competition or less competition. Trade policy, for example. If India is now negotiating a number of FTAs, free trade agreements, that will lead to greater competition. One of the advices when inflation is high is make it easier to import the certain products so that inflation comes down. That comes down due to competition. That is consumer welfare. So here's another policy which is creating a competitive environment. And similarly, there are many other such policies. In that context, what is the behavior which actually limits the impact of that? And that is why CCI comes in. And CCI, I remember when I was in TRI and CCI was being discussed, we were very turf conscious. We didn't want to lose our control over the anti-competitive, addressing the anti-competitive activities. And there was a lot of debate over that. But I feel that, and that's why there is this mechanism for consultation, I think perhaps that needs to be looked at, whether more needs to be done in that context, because anti-competition happens in multiple ways, and to the extent the principles enunciated by CCI are also absorbed and implemented by other regulatory bodies, the scope of that framework, which we were all talking about, gets expanded and impacts a larger part of the economy. So it's in that background that we need to look at how things are changing, and from an economic perspective, and how they are perceived to be evolving over time. One of the major aspects, I talked about this competition or anti-competition related policies of nations, which have become a focus of attention now. And the USTR, the trade minister of US, just recently, last 3-4 days, made a statement that US is interested in developing a coalition of countries to address unfair competing economies. Please note, this is a different level of anti-competition. What will that coalition come up with? What kind of insights? How do they apply to the normal practices of anti-competition? So that is work in progress. And I feel very confident that the CCI will continue to track that, because I've seen the kind of initiatives it has taken in expanding the knowledge base. Payal Malik is here. And also in organizing interactions through conferences, etc., and papers. So, but that is a very significant area which can have an impact on the functioning of or understanding of what is anti-competitive. This is also happening, and an outflow from this, anti-competitive nations is the fact that similar enterprises which are present in more than one economy, can they make adjustments in another economy which have a reflection on the market actions or activities in your own economy? I have certain examples. I don't want to share them right now because that may be, breach of certain kind of confidence. But you just take a look at the markets where very sudden increase in market shares have taken place, and examine what is the reason for that. Is it merely technology, or is it something which could be a geographical collusion? Similarly, conventionally, in fact, when I was a telecom regulator, we used to treat more leniently newcomers, but only up to a time. It was not that they had a free rein. And you face a situation where when there are multiple products which are bundled, how certain kind of products might be priced, or what is the marketing strategy, so that through just one product in various linked markets or products, you can actually undercut or block the economic activity of your competitor. It was very clear in the telecom sector, but this is now something which competition policy is taking a closer look at, where how you are actually linking up certain actions in multiple products or multiple markets which are linked together, the kind of actions you take in one part, which is more contestable, so as to block entry, and the investment you make is as if you're just broadening the moat around the fort which you have built for yourself for high profits. So these are not always easy to understand in terms of whether they are anti-competitive or pro-competitive, because if it's possible to have competition of systems, the result of our analysis may be very different than if it is not possible to have a similar kind of competition from other firms which like to come in. So these issues are evolving, and the work of Competition Commission of India is only getting wider in ambit. There are also economic practices or policies which may create barriers to entry and operations of one segment of a market. The example I want to give in this context is the focus which the government of India is giving right now to e-commerce exports. Now, e-commerce exports is being encouraged both because this is an unexplored, or at least until now potentially unexplored avenue of increasing exports, and it potentially is more attractive for small and medium enterprises. But if there are certain charges which are per transaction, for example, a large exporter gets a revenue in the bank account, and a small exporter gets a smaller revenue but the charge for each transaction is the same. The percentage burden of this charge is far larger on the smaller exporter. Should there be some kind of a thinking to take this impact into account? Again, this is as if a market entry has been blocked by policy action. It may be a result of policy, or maybe by an industry association's decision that this is the minimum charge which should be there. So these issues will come to the forefront when new activities come in. And today is the time when new ways of doing business and new activities are coming in, and new objectives are being emphasized by the government also. What I have just shared with you shows that markets are getting more competitive and anti-competitive. And distinguishing the situations where this happens is based on building a knowledge base and application of economic theories and understanding. And that itself is evolving. For example, the manner in which anti-competitive activities take place in digital. New insights have come in, which are unusual. They are not conventional business practices. At the same time, they will continue to find new ways to try and achieve similar objectives. So the alertness and the knowledge base will continue to be sharpened all the time. And I'm glad that there is clarity. You are engaged in knowledge building, but it is an ongoing phenomena. I remember Alice in Wonderland, there was this statement that you have to run faster and faster to be in the same place. So good luck with that. The other aspect is, when we were looking at a revision of the Competition Act, it was clear that the Act is formulated with considerable thought, and several new phenomena came under the provisions. So you don't need to change the Act, but you need to deepen your knowledge about how the phenomena is taking place, because under the same umbrella, as I've given points about, the actions or the activities to block market access, be it one part of a linked market or some way in which there is a collusion between or understanding between distributors and the company concerned, etc. And there are many. I mean, every product, large product, has a distribution service. How you have that collusion, how it is expressed, and how the adjustments are made in other contexts. So these are the kind of things which examples have to be collected, both from your own experience and others' experience, and also how best practices have evolved to deal with them. So the first concept is that digital enterprises must abide by the law. But what does it mean? It means that the law has certain implications in terms of concepts. Therefore, a number of arguments or practices which on the face of it do not seem to be violating the law must be examined more clearly. Digital also, in my understanding, creates linkages beyond the conventional vertical and horizontal and between systems. So that is another area where it's going to evolve. But the fact that all this is evolving doesn't mean that economic analysis is not at least keeping in place the larger understanding. So the economic principles underpin competition policy, and those same principles help you also assess a situation using the theory of harm, how to analyze the situation, whether the net result is one where the regulator needs to intervene because it is anti-competitive, or whether the regulator should not intervene because it is actually, one, not anti-competitive, or it's actually pro-competitive. I talked about time to begin with. The importance of timely action was made evident by the experience in COVID-19. A number of countries saw price gouging practices of pharmaceuticals. Now, that is a situation where if you have to act, you must act very accurately, precisely, and in a manner that the result is implemented in a quick fashion, because the problem arises in a time band. And if your action isn't taken in that time band, if you keep on investing time, then that action is of no relevance. The harm has been done. So methods to use in various situations, and time is getting compressed now in various activities. Time and geography. Geography is getting erased, the jurisdictional lines, and time is getting compressed. And these two are new phenomena which have become more and more evident over time. But they also require new ways of addressing those situations. So that is something which I'm sure CCI will be looking at. The coalitions of competition authorities would be looking at, and maybe some algorithms, some programs can come out to help there. The last point I want to make is something which mimics the concern about anti-competitive economy. Within an economy, there is a public sector unit, and there is a private unit. If you go to the GATT system or WTO system, the provision dealing with public sector enterprises says they must behave as if they are commercial enterprises. I mean, that is the criteria to judge whether they are actually competing or not. And it is in that context that, and I know that, that the CCI is interested in this. It is in that context, again, certain kind of interactions, understanding needs to be developed. Yet another policy area which, because CCI's tasks include both looking at and addressing anti-competition, but also increasing the knowledge base about it, and also advocating those steps which increase competition. And one of the policies where there will be meeting of minds between the objective of CCI and the Government of India is those policies which it is emphasizing for ease of doing business. When you make it easier for enterprises to function, by definition, the intensity of competition increases. People are more attracted to enter it. They function in a way that they are able to provide products at a cheaper rate. They are able to upgrade quality more efficiently. Therefore, those policies should be watched, and wherever those policies are not functioning for any reason of implementation, perhaps in the database, CCI could flag it as an item for attention for the government, because the government does want it implemented properly. So I've drawn a large kind of canvas, but the underlying framework of that is the simple principles of economic analysis as applied in the evolving assessment of theory of harm and the new situations where completely new behavioral patterns are emerging, both within a jurisdiction of an economy and across economies. Thank you very much.
Thank you very much, Dr. Singh, for a very comprehensive address. Thank you once again for talking to all of us here. And it's time for us to now release the knowledge report prepared by ASSOCHAM and our knowledge partner, Khaitan & Company. Back to business, updates on the Indian competition regime in the post-pandemic times. I'm going to request our chief guest, Shri Ashok Kumar Gupta, Dr. Harshvardhan Singh, our guest of honor, and dignitaries on the stage to now kindly release this report officially. Ladies and gentlemen, presenting to you Back to Business, updates on the Indian competition regime in the post-pandemic times. A knowledge report prepared by our knowledge partner, Khaitan & Company and ASSOCHAM. And it's time for me to now invite our chief guest, Shri Ashok Kumar Gupta, the chairperson of the Competition Commission of India, Government of India, to kindly give the inaugural address. Ladies and gentlemen, 1981 batch IS officer. He joined the Competition Commission as the chairperson in November 2018, and he comes with over 36 years of immense experience, wide-ranging experience with the Government of India and with the Government of Tamil Nadu. Sir was instrumental in formulating several government policies such as the automobile policy, the Prime Minister's Rozgar Yojana, the MAKE procedure in the defense procurement, and establishing the Vardhaman Mahavir Medical College, Delhi. A grand welcome, sir, and we are honored and privileged to have you on our today's program. I request you to please address the gathering now.
Dr. Harshvardhan Singh, former member CLRC and former Deputy Director General WTO and former Economic Advisor and Secretary TRAI, Mr. Manas Kumar Chaudhary, Chairman ASSOCHAM, National Council on Competition Law and partner Khaitan & Company, Mr. Karan Singh Chandiok, Co-Chairman ASSOCHAM, National Council on Competition Law and Practice, Head Competition Law and Dispute Resolution, Chandiok and Mahajan, advocates and solicitors, Mr. Basudev Mukherjee, Assistant Secretary General ASSOCHAM. industry representatives, legal fraternity, officers from CCI, good morning to all present here at this conference. I think Mr. Manas Chaudhary raised a lot of issues, and I think he was quite appreciative of the working of the CCI. Let me also dwell on some of the things which he mentioned. First, about green channel. I was in defense production, and I was in charge of inspection of both domestic purchases as well as international purchases. It came to my notice that sometimes these inspections, they get delayed. I went into the causes. Of course, I mean, you have to do prior inspection, you have to visit foreign countries also. A material cannot be dispatched from the foreign countries unless it gets inspected, because once it gets dispatched, come to India, obviously it cannot be returned. So prior inspection is required at some times. But in some cases, I found that this pre-inspection can be dispensed with. For example, if there are standard items like you are purchasing standard steel from the Steel Authority of India, if you are purchasing oil, POL from oil companies, if you are purchasing, say, standard, even, say, Maruti vans, which are there in the defense from, say, Maruti, such inspections are not required. So I introduced the green channel in defense production. I said there are standard items. Companies can give undertaking that they'll be liable for all the defects, and pre-inspection may not be required. So dispatch can be faster, we can receive it, and if any liability later on comes, then company obviously will have to replace it. So this green channel worked very well in defense production, and it expedited a number of purchases. Repeat orders not required, pre-inspection not required. So this is how we cut down the delays in defense production. When I came to CCI, I came with a single line agenda to promote competition for the welfare of consumers. I think I have not gone through the act. Even today also, after 4 years, I have not fully read this competition law. But this line I remember, to promote competition for the welfare of consumers. When this question came of mergers and acquisitions, I was going through, I found that 98% mergers we have cleared without any change, and in 2% we have provided remedies. And none of the mergers we have blocked, which shows there has to be some area where probably our assessment is not required. So I asked this first question, can we carve out some type of mergers which can be approved immediately on filing and which do not require assessment? So this is how the mind started working, and we came out with this concept of green channel. If parties themselves give an undertaking that there is no competition concern, there is no horizontal, vertical or complementary overlap, then deemed approval can be given, and later on it can be assessed. And there are so many schemes of the government like Tatkal passport. A police verification is done afterwards. So we can see, what I want to say, that we have to be aware of what is happening around in our surroundings. That's why sometimes, too much knowledge becomes a liability. It is better that you come with an uncluttered mind, start seeing things afresh, and then take a decision. Otherwise, you'll always be bogged down by your previous knowledge. Just be aware of what is happening around. This is how we started this green channel. And I think I am happy to say Mr. Manas Chaudhary also is telling that this is the first of its kind in the world, and it's being appreciated. And more than 60 cases have been cleared under green channel. And people have given the correct filing, correct undertaking. We have done assessment of all these 60 cases, and we didn't find any competition concern. It means this message has gone very clearly, and industry is capable of assessing whether there are competition concerns or not. So that is a trust-based system. They themselves assess, they file, it is deemed approved on the same time, at the same time itself, and later on our assessment has revealed the thinking of the industry was correct. So don't you think that there is a meeting of mind between industry and the CCI on this particular issue? So that is why we have to keep telling industry what is in our mind, so that they start thinking from seeing things from the way we look at the things. There has not to be any gap between our thinking and their thinking. And that's why we say that they are the important partners. They become partners. Everybody becomes partner. I don't know about competition law. Today also, I have got very superficial knowledge about competition law. And whatever I have learned from the legal fraternity, listening to their arguments, because I enjoy listening to the legal fraternity, because they come out with so many good things that this is how the things can be interpreted. And of course, our officers are there in the CCI. They keep guiding. So as head of the institution, you have not to do anything, except that you have to understand what they are telling, and then see it from the perspective of the economy also. I'll give you another example. Like when you say to promote competition for the welfare of consumers, keep this line in mind. A number of cases came, and Mr. Manas Chaudhary also made certain observations also. A number of cases came where we found contraventions. But then we also realized these are small companies, MSMEs. If we put penalty on them, then what we'll be doing basically? They have to deposit penalties, and we'll be sucking out working capital from these MSMEs. And it may also result in folding up of some of these MSMEs. Now, if the number of entities come down, does it promote competition or does it hinder competition? From my point of view, entities should survive, so that number of entities are more and competition is promoted. So a number of judgments we have come out with, where not only they were SMEs or MSMEs, but they also fully cooperated. That's also important. And sometimes they are caught unaware because they have been following this practice for the last 30-40 years. They said, we have been doing this for the last 30-40 years. Suddenly 2009 this act came. We are not aware of this act. So it is to some extent our folly also that we have not taken this act across to the industry, to all the sectors, to MSMEs. And then they said, we have fully cooperated, whatever you say we will do, in future we will not do, but please don't levy penalty, otherwise we will be in deep distress. So there we take a nuanced view that penalty may not be. I think Mr. Manas Chaudhary also has clarified this, that yes, in certain cases we levied penalty in the COVID time also, because obviously they were not MSMEs. So this is how a departure, we don't go strictly that contravention and then penalty, contravention and penalty. No, I think these two things need not be linked straight away. And as we have got legal division also, they advise contravention, yes. We never said there is no contravention. We said yes, there was contravention. It means majesty of the law has been upheld, but justice demanded that there should not be any penalty. So law and justice, that's why there are two wings, two different departments in the government also. We should not meddle with the law, but justice becomes a different cup of tea. That's how we looked at things. And then another thing I found, that a number of cases are coming to us which pertain to state governments, because state governments, they do a lot of procurement for the welfare of the people. And there, they are not fully aware of, even the procurer is not fully aware of how the tender designing has to be done, how to make the tender competitive. And that is why we thought we need to have outreach with the state government also. We opened up 3 regional offices, Delhi, Bombay, Calcutta, and we came out with a state resource person scheme where we are appointing 2 persons, 2 middle-level officers of the state, retired state, 2 middle-level officers who retired from the state government as state resource person. And they will interact with the various procuring departments. I have met a number of chief secretaries also. I have explained the scheme that you appoint 2 people. We don't want to impose 2 people on you, because again, it can always be an issue of central-state relationship also. I said, you appoint, they'll be paid by us, and they will only go to the various departments, tell about competition law, because we have to spread the message of competition law. Still, I think it has not gone to the nook and corner of the country. Yes, big industries are aware, everybody is aware, but small people, small industries, they are not aware of this. And how to implement it, because we just can't implement, because see, like suppose there are small, if there is a one person proprietary firm. Whenever they apply for the government tender, they hand over this to some agent, because they don't have time to fill up the form, they don't have that much of expertise. Same person is purchaser, person is marketing also, accountant also. So, but in competition law, we say yes, the form has been filled up in the same handwriting, it has been loaded from the same IP address, and hence it is a cartel or collusion or something like that. It cannot be seen from that perspective, because he doesn't have wherewithal. He is making daris, he is making pants for the defense. He has no, I mean, he just can't go into these things and increase the overhead cost. I'll give you another example from the railways. See, that's why the things are quite complex. Things have not stabilized. Our procurement system is very much dependent on the procurer also. Procurer plays a very important role. We only see the supply side, suppliers only. Yes, suppliers have colluded, they have talked among each other, they have quoted the same price, and hence there is a contravention and they have to be punished. Next time what they will do? They will stop talking, they will find ways to how to communicate with each other. They can find ways, not number one. Then they will say, let's do some change in the pricing here and there. They will find ways, but they will do the things in similar manner, I am telling you. We are not addressing the problem. We are only, by doing this thing, the problem goes underground. People start doing things in a different manner, because we don't trust them. That is why I think we have to listen to them, talk to them, not strictly follow the competition law, section 3, section 4, all those things. But what are their issues? Have we understood their issues? Have we talked to them? How the government is procuring. I have done procurement in government. I have told suppliers that I want 3 suppliers, and I will divide 1/3, 1/3, 1/3, quote the same price, because then I can divide comfortably 1/3, 1/3, 1/3. But I will give you only this much increase over the last year. I have done all those things. This was the price last year, 5% increase we will give this year. That is the inflation rate. Plus 5% you quote, 1/3, 1/3, 1/3 I will distribute. Under competition law, this is a state of a collusion, contravention. How do we deal with the situation? I want 3 suppliers. I want to divide, because L1 doesn't work. I want to have a backup supplier also. If he backs out, then what do I do in the defense? The same thing with the railways. In railways, we found a tender. That person is just adding 5% every year. They are quoting the same price, but adding 5% every year. How can you say they are making windfall profit? If it is a cartel, they can quote anything then. But what they are doing, 5% every year they are increasing, which means there is some direction from somewhere to just increase 5% over the last year. It's a very, very clear indication. In some years there is no increase also, but the same price. We have got a case. They quoted the same as last year, at exactly the same price, but we say it is a cartel for same price. Because they have to talk among themselves and quote the same price. Suppose Railway Finance says, no, this year we are not going to give you an increase. We have budget constraint and all these things, but these people are dependent on the railways because they have no other means. So they quote the same price. Next year we'll give you something, but don't worry, but this year same price. This is how the procurement is happening. As a legal fraternity, you have to find out the ways to deal with the situation. I talked to the railway chairman. He said, tell me the solution for that. Okay, we can have seminar, you can tell all those things as per your law, but how do I change my way of working? I am not giving them windfall profit. I am seeing last 3 years or 4 years of prices, and then I am giving some escalation. What's wrong in that? I'm not saying that everywhere there is no cartel, but there are a lot of cartels. But I'm just giving some situations which can be dealt with differently. So we have to put our mind together as CCI and the legal fraternity how to deal with that, and not just throw it under investigation, because investigation is a very long-drawn process, and these people feel harassed when they are called for deposition. I get phone call. If I have to come from Kanpur and depose, then I have to close down my shop. And I have to make arrangement for stay here also. We do not know, DG will call today or next day. He may call today, but he may not. All those issues are there always. So see the harassment for the small people. They don't have the wherewithal. They can't take the legal help also. That also is very costly. So we have to see it from, it is a modern law. Yes, we understand that. It should be there, no doubt about it. But how it has to be applied, I think we have to apply our mind. And we have to make a distinction on case-to-case basis. That's why I'll say it's an economic law, it has to be subjective. There has to be subjective satisfaction of the commission. We just can't apply the same yardstick in each and every case. In commission also, I have told don't give precedents, because markets are dynamic, they keep changing. 3 years back what happened, I think that is not relevant. And that is why the market studies become important. What are market studies? We just want to understand the business model, how the industry works. So that when our enforcement decisions are informed by those market studies, how can we do justice with the industry if we don't understand industry? That's why a series of market studies we are doing, just to understand the industry, and that's why I always say, please cooperate. You just tell how do you work. Some people have got apprehension that the data given or the information given may be used against them. No, it's not like this. That's why CCI is a complex organization in that sense. We want to do advocacy also, we want to apprise industry also. At the same time, we have got enforcement activities, we have civil code, we do adjudication also. But these are two hats. I think there is a clear division between these two, and we need to make this distinction understand to the various stakeholders. Now amendments have come. I think our honorable member of the CLRC, he has dwelt on those amendments also. He was part of that also. Let me tell you, I can debate with anyone. None of the amendments is increasing compliance burden. Each and every amendment has been seen very carefully, and they are promoting ease of doing business by providing regulatory certainty, by promoting trust-based regime, by doing faster market correction. Just bring to my notice any amendment which you feel is regressive. It's a very good area, I think, because before they become law, they come in the act, I think we need to thoroughly discuss each and every amendment. And all the apprehensions of industry should be removed. When it is not our intention to increase the compliance burden, then why we should push against the perceptions of the industry or legal fraternity? I think, and if some amendment we ultimately admit ki is not good, we will drop it. There is no harm, because it's not the intention of the government to increase compliance burden. Like I said, to promote competition for the welfare, government agenda is simple, to promote ease of doing business. Amendments are only a means to promote that agenda. Today, you see, like limitation clause. You cannot rake up issues where the cause of action lies, say, more than 3 years old. Why? To provide certainty. Otherwise, any industry can be dragged to the CCI. This happened 10 years back and CCI should take action. Even in income tax also, you see the income tax. They say income tax returns beyond this or so much old will not be opened. Why? Otherwise, everybody will be in the perpetual fear of that any income tax return can be opened. Government is moving in that direction. So see, if you see from the higher perspective, everything you can see the clear understanding, clear thread is running that we have to promote ease of doing business. We have to provide certainty to the business community. And that's why I'll mention these three amendments which are most important: settlement and commitment, deal value, and what do I say? One more commitment, settlement, commitment, deal value. And yes, of course, I mean, that I told you, to provide certainty, not more than 3 years. If the cause of action lies beyond 3 years, it will not be open. So these three are very important amendments. But we have to now operationalize them. And for operationalizing them, I think we had to put our head together. We had to, like deal value. Now, some people have got apprehension that yes, now one more limb has been added apart from asset and turnover. But deal value, if you see in the overall perspective, it will be applied or it will be triggered in very, very few cases. Very, very few cases. We have done our empirical studies. We have found that almost say 100 cases or 100 mergers and filings are filed every year. Maybe a few more in single digit. Not more than that. I'm very clearly saying single digit. It can be 1, 2, 3, 4, something like that. But it is important to capture those few cases also. Otherwise, they will distort the market. So it is in the larger interest that those cases are assessed by the commission. And just we have got de minimis, same provision is there India nexus. If the target doesn't have substantive operation in India or it operates outside, of course, then they will be out of the deal, even if the deal value may be more than 2,000 crores. So this is how the de minimis parallelly, will be applied in this case. So we have to come out with very, very carefully what is the India nexus, how do we define India nexus. It cannot be in terms of the monetary value. It has to be in terms of market facing factors like users or sellers or network effect or transactions, etc., all those things. And we may have to have several parameters depending upon the type of industry we are dealing with. So again, it's a very elaborate exercise. I think we'll consult all the stakeholders and then only we'll come out with those regulations. But they have to be dealt by regulations because they'll be dynamic in nature. We don't want to freeze them by law so that we can keep changing them. So my central point is that CCI, legal fraternity and industry, they are three important partners in every case, every deal. And we should not see each other from the adversarial relationship. We should be frank enough to air our concerns. And let me tell you my personal experience of the last 4 years that I have really enjoyed my court work, listening to the lawyers, listening to their arguments, because that otherwise also enriches you. Outside the competition law also. So it has been a very, very satisfying tenure, and I am definitely grateful to, of course, our legal fraternity and the CCI officers, because some of them has got fantastic knowledge, I am telling you. They are the best in the world, no doubt about it. They can be picked up by any institution anywhere in the world, and they will do wonders. That much of expertise is there in the CCI. Similarly, bar, the way they argue, It is just, I think, I mean, because you might be aware of all those things, but since I am coming from a different background, for me it was quite an eye-opener. And they were so courteous. I mean, we started refusing adjournments, and then afterwards I don't think we received any request for adjournment also. Because that much of understanding came between bar and the commission. That case has been listed, it will be heard. So, thank you very much. I think I have nothing more to say today. I had a written script, but I thought let me just deviate from that and tell you what is in my mind. And I am sure that we are definitely facing a big challenge now in the terms of digital economy, and everybody is clueless what exactly is happening, because things are moving much faster than the way we look at things. So we have to be very, very dynamic in our approach. And how do we upgrade ourselves? How do we be so dynamic? And then again, it's a legal challenge again. I'm saying why I'm saying, because when you become so dynamic, markets become so dynamic, you start looking at things so differently from each case, then legal fraternity obviously will say that there is no clarity or certainty. That has to be understood, that much of certainty cannot be there, because if case is, one case is 7-8 months old, then the after 7-8 months you may start deciding things differently. So that much of uncertainty definitely will be crept in. But we have to upgrade ourselves, and I think all of us, whether in India or anywhere in the world, we are at the same level so far as digital economy is concerned. And we are not lagging in any way. In fact, some of our judgments, they can be, I'll say, a role model for other competition authorities also. So thank you very much for giving me time. Thanks a lot.
Well, thank you very much, Shri Gupta, for talking to us. The honor is indeed ours to have you on our today's program, and thank you once again for sharing with us your thoughts and insights. As a small token of our appreciation and gratitude, I'm going to request Mr. Basudev Mukherjee and Mr. Karan Chandiok to kindly present a little memento on behalf of all of us here at ASSOCHAM to Shri Gupta. Thank you once again, sir, for sparing some of your most valuable time and joining us here on our today's program. Requesting Mr. Basudev Mukherjee and Mr. Karan Chandiok to kindly present this memento to our chief guest, Shri Ashok Kumar Gupta, Chairman, Competition Commission of India, on behalf of all of us here at ASSOCHAM. I'll also request Mr. Basudev Mukherjee and Mr. Manas Kumar Chaudhary to present a memento to Dr. Harshvardhan Singh and thank him, our guest of honor, Dr. Harshvardhan Singh. On behalf of everyone at ASSOCHAM, we'd like to thank you, sir, for joining us today. Well, in fact, we've almost come to a close of this inaugural session. I'm going to request Mr. Karan Singh Chandiok to kindly give the concluding remarks now and propose a formal vote of thanks.
Very good morning to everyone. Before I start, Honorable Mr. Ashok Kumar Gupta, Mr. Harshvardhan, Mr. Basudev, my senior, Mr. Manas Kumar Chaudhary, the backbone of the CCI, who's on the front row today, especially I would say the generals, the advisors and the secretaries, ma'am, Jyoti ma'am, Mr. Manas Kumar, Manish Kumar Govil, and who's just left perhaps is Ismail Palik, and my members of my very dear bar and industry leaders like Mr. Sachdev, who's here. Thank you very much for coming. Dr. Harshvardhan said, time is capital, and nothing is more valuable than a weekend. So thank you so much for coming on a Saturday, first of all. I'm going to slightly break protocol here, and instead of saying concluding remarks and to conclude and summarize what has happened, because I think the points, for example, Dr. Harshvardhan made about how the CCI and the government have to come together to, the focus of competition policy enforcement has to be ease of doing business. Equally, we have to be careful about all the barriers of entry that competition policy or policy in itself may create. Because at the end of the day, the focus of competition policy is consumer welfare and whatever we can do to enhance consumer welfare. And that as an industry body, as ASSOCHAM, in policy design, we've always been at the forefront of it, and we're very grateful for the opportunities we've had with the Commission and the Government of India in order to enhance that focus. But I think for us, I think for what Mr. Manas Kumar Chaudhary started off by saying was the different phases, as he put it, on competition law enforcement in the last 13 years or so. As far as India is concerned, I think I would equally divide it into 3 phases. There's the first phase, which was the stabilization phase of what the Competition Commission was going to be, so it was laying down the infrastructure, creating the body. I remember the first time we went for inspection, nobody knew how to do inspection. So we had to, as we do inspection in court, we started actually, took out a register and made lines to say who will come in the register and who did what, so on and so forth. Equally, when we go to the DG office, there was nobody to take down notes in a deposition. And half of the time, we were taking down notes ourselves for the DG office in front of them, making sure that as what was being said by the witness was being put together in the correct format. And we've evolved from there. Some of it, some of the procedures have become stricter, I would say, but equally what has remained is this collaboration between industry, regulator, and the ones in the middle, which is the bar. But the second phase was the phase of interpretation. The interpretation phase was what the law is. What do these 3 sections really mean, and what do they translate into for businesses? And the third phase, which is the last 4 years under your leadership, Mr. Gupta, has been the phase of not what the law is, but what the law ought to be. And for that, we're very grateful to you, because the law itself has to respond to the dynamism of markets. And with market, it must evolve in itself. It's a living law, and it must evolve, and it has, through the innovations such as green channels, through the innovations which are going to come through in the form of settlements commitments. And the 3 points that you laid down in your speech, which was the 2 important points, which was of settlements and commitments and of merger control, are actually our first and second technical sessions, because they are so important. The third you mentioned was about digital economy, and that is the third technical session that we have today, and we're very grateful to all our speakers who have come from far, from all the way from Austria, Judith Feldner, others who are joining us online, so that there is this dialogue on what the law ought to be in the coming years. But I think if I were to talk about this phase under the leadership of Mr. Gupta, I think that goes to your personal qualities, is one of kindness, one of open dialogue and understanding of what there is. And I think from all of us who just heard your speech can realize the fact that it is this perspective that you have brought to the Commission to humanize the process, which has been the most important contribution in the last 4 years to competition law. To understand the fact that there is perhaps no cartelization, or perhaps the cartelization, or what we may technically call cartelization, may just happen because that is the way procurement design is taking place. So this open dialogue, which started during the CLRC process, leading to innovations such as Green Channel, are a testament to this transparency and accessibility which the Commission has now been known for. Then equally is the openness during oral hearings. It's been an absolute pleasure to argue and present before you, because a lot of the times you're not sure in which manner your arguments are going, but but you would always ask questions and you would always show this curiosity, which would allow us to know that whether or not we're on the right and wrong track. So thank you so much for the patience. A lot of times when the Supreme Court or High Court judges stay beyond their official working hours, it's plastered over the newspapers every day. But a lot of you may not know that sometimes the commission keeps us awake, I would say, because sometimes we drone out hearing our own arguments till 9 p.m. and credit that during this entire time, while we may fall asleep listening to ourselves, the commission has not. So thank you very much for that. I would go on to just to make this point that what we have seen over the last 4 years, and the industry, as an industry body, we're very grateful and appreciative, is the fact that there is this trust-based enforcement. That there can be, the focus is on reform, focus is on market correction. It is not on as what we call in jurisprudence, the deterrence theory. Because that deterrence theory, as Mr. Gupta pointed out, could actually lead to unintended consequences of companies folding up, or their business model is changed so much that they would no longer be able to function as a competitor in the market. And that is not the intention of competition law. The intention of competition law is not to fine. The intention of competition law is to bring about change in the competitive process. And with that, there has been a deference to business models. There has been a deference to enforcement which is based on evidence, which is based on effects, and that has been, again, part of that journey from what the law ought to be and how it should be enforced. So from our perspective, as an industry body, as the bar, or rather, if I may misquote Alice in Wonderland, all of us will have to run faster and faster to remain in the same place as you are leaving us. So with that, thank you very much to all of us who have taken out time on a Saturday, to come, and most importantly, to our eminent speakers on the dais for giving us this engaging thoughts and leaving us with these engaging thoughts. Thank you so much. And just as a token of the appreciation from the industry, I'd like to request Mr. Manas Kumar Chaudhary, Mr. Mukherjee, to present a small token to Mr. Ashok Kumar Gupta. Thank you once again, and now we'll be going into our technical sessions. So with that, sorry, there's one question. Do you need a mic? You also need Satoshi.
I'm going little away from the protocol because in the presence of chief guest, one is not allowed to speak. But since my point is very important to be discussed in your presence, so I am here. Sir, we are generally looking at competition as a crime. And we are creating laws and laws over the laws.
Laws and laws?
We are creating laws and laws over the laws, looking competition as a crime, whereas it is not. Competition is necessary for growth and innovation. Second, we are enacting laws common for all, whether it is large scale, whether it is medium scale, whether it is MSCME. Competition amongst these two big wigs and then small is not necessary. Is not a competition. Laws should be enacted differently for different segment. MSMEs, laws should be different. They should compete with each other. Rather than larger, they cannot. This is my submission to be discussed in your presence because it needs thorough discussion on this. I would request you to give me time. I'll discuss with you in office. I am gold medalist in laws, so I need to discuss all this in details with you.
No, I think.
If you permit me some time.
No, of course. I think I can answer it, but it's better that we discuss it separately, because I think you have got points, but I can answer those points, and whenever you want next week, you can come and we will have discussion. Do you want me to answer right now?
No, sir. Thank you so much. Thank you so much, everyone. Sorry, sir, we are out of time, but maybe if sir can spend 5 minutes after the session, if that's all right. Yeah. 5 minutes after, yeah, okay. Thank you. Thank you so much.
Well, thank you, everyone. With that, we conclude the inaugural session, and I'm going to request our chief guest if he can spare some more time and join us for the technical sessions. I'm going to request everyone to kindly be here. We are going to continue with the program and head straight to our next session, which is a technical session on the contours of anti-competitive agreements and the journey of enforcement. So far, we have an esteemed set of panelists to discuss settlements and commitments, leniency plus, the limitation on filing information, complaints on issues previously addressed, and withdrawal of information remedies that have been offered. Just to name a few that we are going to be discussing in this particular session, requesting everyone to kindly remain seated. We promise you ample time and opportunity for networking during the tea break and the lunch break. For now, I'm going to request everyone to kindly remain seated so we can continue and head on to our next session. We are already running a little behind schedule, so we request everyone to please be with us as we proceed to our next session.